Brown versus the Board of Education. Only one-third of states segregated their schools by law. At the time of the Brown versus Board of Education ruling, 17 southern and border states along the District of Columbia required their public schools to be racially segregated. An additional 4 states, Arizona, Kansas, New Mexico, and Wyoming, permitted local communities to do the same. Although black and white schools were supposed to be separate but equal, in accordance with Supreme Court's 1896 Plessy v. Ferguson decision, but in reality, they were anything but. In 1954, southern black schools received only 60% of their per-pupil funding as southern white schools, up from 45% in 1940. Many southern black schools therefore lack such basic necessities as cafeterias, libraries, gymnasium, running water, and even electricity. The cases that came to be known as Brown versus the Board of Education was actually the name given to 5 separate cases that were heard by the U.S. Supreme Court concerning the issue of segregation in public schools. These cases were Brown versus the Board of Education, Topeka, Briggs versus Elliott, Davis versus the Board of Education of Prince Edward County, Virginia, Boiling versus Sharp, and Gebhardt versus Ethel. While the facts of these cases are different, the main issue in each was the constitutionality of state-sponsored segregation in public schools. Once again, Thurgood Marshall and the NAACP Legal Defense and Education Fund handled these cases. Now, before Brown actually took on the Board of Education, there were 5 lower court cases that all ended in defeat. None of the 5 lower court cases did away with the laws mandating segregated schools in Kansas. For example, the ruling held that Topeka's black schools were substantially equal enough to meet the Plessy Doctrine. Nonetheless, the plaintiffs received some helpful signs that outcome would change on appeal. In Southern Carolina, Judge J. Waites Waring issued a dissenting opinion in which he called segregation in education an evil that must be eradicated. In Delaware, the court found that the 11 black children named in the case were entitled to attend the white school in their communities, and in Kansas, the court conceded the segregation and harmful effects. Brown versus the Board of Education started off as 5 cases. In 1950 and 1951, lawsuits were filed in Kansas, South Carolina, Virginia, Delaware, and the District of Columbia on behalf of black elementary school students who attended legally separated schools. Despite differing somewhat in the details, all alleged a violation of the Equal Protection Clause of the 14th Amendment. Dozens of parents signed on as plaintiffs, including Topeka, Kansas, a resident, Oliver Brown, and a welder and a World War II veteran who served as an assistant pastor at his local church. When the Supreme Court consolidated the cases in 1952, Brown's name appeared in the title. This was done on purpose, a Supreme Court justice later explained, so that the whole question would not smack of being a purely Southern one. Brown versus the Board of Education was actually a unanimous decision. Because following the oral argument, Warren told his fellow justices that the separate but equal doctrine should be overturned. He then went about wooing those still on the fence, telling one that a dissent would encourage resistance in the South. In the end, all 9 members of the court joined an opinion that Warren described as short, readable by the lay public, non-rhetorical, unemotional, and non-accusatory. Education is the very foundation of good citizenship. The ruling stated, to separate black children from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone.